I thank the gentleman for yielding. Mr. Speaker, last month President Obama nominated a fantastic jurist, Judge Merrick Garland, to the court. Seconds later, Republicans announced that he would not receive a vote, a hearing, or even a courtesy meeting in many cases. Judge Garland has a sterling reputation as a brilliant, centrist, and above all, fair jurist, and has been praised by members of both parties in the past. He served in the criminal division of the Department of Justice before his nearly two-decade-long career as a U.S. Circuit Court judge. Garland is a Harvard University and Harvard Law graduate. He clerked for a U.S. Court of Appeals judge and then for Justice William Brennan on the U.S. Supreme Court. During his stint with the Department of Justice, he was dispatched in the aftermath of the Oklahoma City bombing to help set up the prosecution team and help investigators build a case. And when Garland was appointed to the U.S. Court of Appeals, he received a broad and bipartisan vote. There is no doubt that Garland is superbly qualified. This nation's Constitution expressly states that the President has the power to appoint Supreme Court justices with two-thirds of the Senate approving. Nowhere is there some kind of an asterisk stating that during their last year in office or even during the last few weeks of their term, that the President must relinquish this power to a successor. President Obama was elected by the American public in 2012 to serve another 4 years in office. With 9 months left in his term, there is no excuse for the Senate to block him from filling this Supreme Court vacancy. Precedent demands action. In the past, 6 previous Supreme Court nominees were confirmed by the Senate in an election year, including current Justice Anthony Kennedy, who was nominated by then-President Reagan. A Republican president who was in his final year of his term, a Democratic Congress hoping that one of their own would replace him in the Oval Office. If that's here, it is. But instead of the partisan gridlock in the midst of a heated presidential campaign, in 1988, Kennedy received a fair and lengthy hearing chaired by then-Senator Joe Biden, and then received an overwhelming 97-0 bipartisan vote. The Supreme Court is a co-equal branch of government, not to be trifled with, not to be demeaned like some administrative backwater, and certainly not to be made the partisan and political plaything of a Senate GOP leadership desperate to hold on to its majority at all costs. Judge Garland deserves a full and fair hearing before the Senate to discuss his qualifications and judicial philosophy, and he deserves an up or down vote on his nomination as soon as possible. To do otherwise would set a dangerous new precedent that further politicizes the judicial nomination process and departs from our constitutional system. Thank you, Mr. Speaker, and I yield back.